That, Natalie. I'll keep an eye on it.
All right, thank you so much. Okay, Greg, go ahead and take it away. I did have your bio, but I may just ask that you introduce yourself for this one. Otherwise, I'm going to have to pull up my email. So
yeah, I'll be glad. I'll be glad to do that.
Great.
Okay, and before I get started, I understand you use comments, but I certainly welcome anyone as we go through to stop me if you have any questions or comments that are relevant to the topic. This is certainly a training presentation, but to the extent that it can be interactive and people have relevant questions or particularly relevant experiences to share, I think that's helpful here. One of the things about the CPARS system is that the CPARS are not published for the general public. And so a lot of what each individual contractor experiences is based on, or a lot of each individual contractor's knowledge is based on its own experience and anecdotes that it can pick up from other contractors. So certainly anything that anyone wants to share about what you've seen or experienced with regard to CPARS will be relevant here. Can you go to the next slide, please? So just a quick introduction. My name is Greg Jacobs. I'm based out of Washington, D.C. Today I am joining you from my home in Maryland. I'm with a law firm called Polsinelli. We're a national firm. We have about 900 lawyers spread out in 23 offices around the country, pretty much from coast to coast, Seattle to Miami. We have an office in Northern and Southern California, a large office in Denver, and a number of other places, including obviously Washington, D.C. And I'm a government contracts lawyer. I'm the chair of our government contracts practice group, and I work with government contracts clients on a wide range of issues. Some of those issues are day-to-day counseling on things like CPARS, other performance issues that come up, contract interpretation, teaming agreements, subcontracts, those kinds of things. I also litigate, so I litigate bid protests, and then also contract disputes, including contract disputes with the government, including disputes about CPARS. And I'll talk about one particular case that I've had and some of the lessons that I learned from that case a little bit later in the presentation. Next slide, please. So as you know, our topic today are CPARS, Contractor Performance Assessment Reports. Today, we're going to talk through about 8 different topics about CPARS. First, we're going to just cover the basics. What are CPARS? Most of you are probably familiar with the topic generally, but we'll just get a baseline together on that. Then we'll talk about how the government uses CPARS, what the FAR requires of the government with regard to CPARS, the preparation of CPARS, which is certainly one of the most important steps in the process, and then how CPARS are published and the contractor input on that process. I'll talk about the role that CPARS do and do not play in bid protests, and then how contractors, under what circumstances and how contractors can challenge their CPAR ratings if they disagree with them, which can happen fairly frequently. And then finally, we'll spend some time at the end, probably the most important part, drawing on all the other elements we've talked about to discuss some best practices in really how to maximize your CPAR ratings. And then if you disagree with your CPAR ratings, your best practices for disputing and hopefully getting them overturned. Next slide, please. We'll start with some basics, and gonna go ahead and start with terminology. A CPAR is a Contractor Performance Assessment Report, and CPARS is the Contractor Performance Assessment Reporting System. People oftentimes use those interchangeably. When I talk about it or write about it in this presentation, you'll see me using CPARS with a little s to refer to multiple CPARS as opposed to the big S, which talks about the entire system. It can be somewhat of a pet peeve that people talk about CPARS with the big S to refer to the report. But those are used interchangeably and everybody knows what they mean. But what a CPAR is as documented in the federal acquisition regulations, is it's the government's official source for past performance information. The FAR requires, with very few exceptions, that in all procurements over the simplified acquisition threshold, that is, all contracts and orders that exceed $250,000 in value, that the government, when making award, consider past performance. And the government does that in a number of ways, but the official government recording system for past performance is the CPAR. Next slide, please. So CPARs are stored at cpars.gov. There is a thought that eventually that will be all folded into sam.gov, which will become the government's one-stop shop for all contract-related databases. But for the time being, those are located at cpars.gov. And cpars.gov is accessible by both government officials and by the contractors. So government officials who have the proper permissions access cpars.gov to draft the performance reports, to review them, to review contractor comments on CPARS, and then ultimately to finalize them and publish them. They also, acquisition officials, access the CPAR records in cpars.gov as part of past performance evaluations, as we just talked about. And then also the government officials visit the website to manage accounts and records, which they're required to do by policy very strictly to make sure that only people with the right authorization are able to access the system and draft or revise records. Because CPARS information is considered source selection information, and it is considered to be sensitive by the government. Contractors with the right authorizations can also access cpars.gov to review and comment on their evaluations, and then also to review their records and manage their users and permissions. Next slide, please. So what is the government using CPARS for? What past performance information is relevant for the government's consideration when it's looking at a contractor's previous CPARS? Well, the FAR actually spells out pretty clearly what those factors are, and for the most part, they are what you'd expect. Whether the contractor met the requirements of contract performance, whether the contractor was able to properly forecast and control costs, whether the contractor met the required schedule and deadlines for the contract, and then generally whether the contractor engaged in a cooperative business relationship with the government and in interactions between contractor personnel and government personnel. So those are the aspects that you would expect to see in a past performance evaluation, and those, as we'll talk about in a couple of minutes, are largely reflected by the evaluation categories that are required for each CPAR. The government's also required to evaluate a contractor's integrity and business ethics and its business-like concern for the interest of the customer. And those are maybe not as intuitive, but it's a really important part of not just past performance, but also the question of whether a contractor is responsible. Some of you who are familiar with the acquisition review process will know that when a contractor is being considered for a contract, one question is, aside from whether they wrote a great proposal and were able to meet all of the requirements of the contract, whether this is a contractor that is responsible, whether this is a contractor that has shown itself to be a good business partner for the government, or whether there are broader compliance or integrity concerns that would make this contractor not eligible for the contract. And that's something else that CPARS are used to evaluate in addition to just your basics of performance in accordance with the requirements of the contract. Next slide, please. So as we just talked about, in practice, CPARS are primarily used for past performance evaluation. So that's the primary purpose of them. The government is reporting CPARS information, and then that agency and other agencies are using that information when evaluating whether the contractor, based on its past performance, is likely to perform well on this new requirement that's being awarded. And so you'll oftentimes have a multi-pronged past performance evaluation in a solicitation. The agency will often ask for specific contract references that it will review that are recent and relevant to the requirement that's being solicited at that time. In addition to that, the agency can review whatever other information it has at its disposal, whether or not that is included in the solicitation. So you may send in your 3 past performance references, and you may say in those references, we did work that was very similar to the present requirements. The size and the nature of the work is directly relevant. We got great CPARS ratings. And here they are. And the government will either take the CPARS information from you if you provide it there, or go check itself to see what the CPARS ratings were on those contracts. But it can also look at all of your other contracts and see whether there were other contracts that it considers to be relevant that were where you received great CPARS ratings or not as great CPARS ratings. So even if you don't include a contract as a past performance reference, if you have negative CPARS ratings on your file in the CPARS system, there is a concern that when the government's evaluating you for any kind of award, those can come back to haunt you. Those are the government is per the FAR. It's only supposed to consider past performance information in the CPARS system that is within 3 years of the completion of performance. So 3 years after the contract ends, or after performance ends, that's how long the government is supposed to consider a CPARS. And so that's how long a positive CPARS rating can help you, and how long a negative CPAR rating can hurt you. And that period is longer. It's actually 6 years for construction and architect and engineering contracts. As I mentioned before, CPAR information can also be used to assess integrity and responsibility. So even if it's not directly related to the performance of the work or the schedule or the cost control, CPARS information can be used if there was a major compliance concern or a major integrity concern that gets reported in the CPAR system. That information can be considered as well. It looks like we have someone with a hand up. So I invite you to go ahead and chime in with whatever question or comment you have.
Thanks, Greg. I just want clarification on the definition of environmental services and whether that would be under 3 years or 6 years.
So environmental services would, in my reading, typically be within 3 years, as long as it's not construction or architect and engineering work. Those, you'd have to look at it at the specific nature of the work. The architecture and engineering work, usually when you're performing that's procured under the Brooks Act. It has a very special section of the FAR. It's a different kind of procurement. The architect and engineering contracts are, the capabilities are assessed separately from price, and then once there's a notional awardee selected, then the government negotiates price at that stage. So typically, when you're performing an A&E contract. Construction also has a specific definition. It's not always quite as easy to tell, but as long as you're outside of the FAR's definition of construction work, which in most cases for environmental services you should be, those are the kinds of services that should be covered by the 3-year limit.
Doug, if the task order has some construction elements to it, and there's a Davis-Bacon wage determination included, then it's then there's certainly some gray areas to which side of the line it's going to fall in versus services 3 years, construction 6, and in such special cases we can dig in a little bit and see if we can get our way one way or the other.
Okay. Yeah. Thanks.
Yeah, Chris, that's was that Chris who said that?
Yes.
Yeah. And that's a great indicator. If you've got a Davis-Bacon wage determination as opposed to a Service Contract Act, that usually means that at least some of the work is construction. It's a great point. Okay, next slide, please. Okay, so what does the FAR require with respect to CPARS? For all contracts and orders, so those are standalone contracts, and then also task or delivery orders under IDIQ contracts that exceed the simplified acquisition threshold, which, as we said, is $250,000. CPARS are required at least annually by the agency. And in my experience, annually is typically what you see. You don't normally see an agency going above and beyond and doing more than annually. Although I guess that's always possible. The thresholds, once again, are a little bit different for construction. That's set for contracts and orders valued at $750,000 and greater, and also any contract or order that is terminated for default in the construction space requires a CPAR. And then for A&E contracts, just valued at $35,000 and greater, you need a CPAR at least annually. And one of the things the FAR requires, and this is an important point, in addition to the standard CPARS evaluation topics, which we'll talk about momentarily, the agency is required to consider if there are any reduced or untimely payments to small business subcontractors. So if you are working with small business subcontractors and they're complaining about not having been paid or having been paid less than they were owed, that's information that the agency is required to address in a CPAR. Now, it's important to note here that that requirement does not extend where there are bona fide disputes about whether the subcontractor is owed the amount, if there's a dispute between the prime and the sub with respect to work, et cetera. So you just want to be cognizant of those issues and make sure that the agency understands if there's a sub complaining about having not been paid or complaining about being short paid, that the contracting officer is aware of your side of the story if there is in fact a legitimate dispute, and you can say, we didn't pay them because they didn't do the work or they didn't do the work right. And then hopefully the agency doesn't see the need to address that particular issue, and it can stay out of your CPAR records. Next slide, please. So in the preparation of CPARs, each agency has its own documented CPAR process. They don't deviate that much. I've had the opportunity to review a couple different agencies. Mostly the point is to assign different roles to individuals within the agency. So it says who's responsible for drafting, who's responsible for reviewing, who's responsible for approving. It's pretty universal that there's a reviewing official who has the final say on issues in a CPAR. That person is usually pretty senior within the agency acquisition framework, and frankly may not be all that involved in the day-to-day performance of the contract, and that's somewhat intentional. Because the idea is that a CPAR should be fully documented by the agency. So the rationale for a particular rating should be spelled out such that a reviewing official, without any prior knowledge of the contractor's performance, can determine whether the rationale justifies the rating, and where it doesn't, can push back and say, we think that you haven't fully explained why you gave this rating, or have you considered this, et cetera. So it's a system that's designed to have some checks and balances, and it's also designed to have input from a variety of different functions within the agency. So oftentimes the contracting officer will take the lead in CPAR drafting. It's not a requirement, but that's usually how things work. But the contracting officer is getting significant input from the program office, from the technical office, and from really, if there's a quality mechanism within the agency, from the quality office, and just generally getting a range of inputs that all inform both the ratings and the narrative to support the CPAR. The requirement is one key requirement is that the CPAR has to describe the work. It's not just designed to give the contractor a report card. It's also designed to document what the contractor's work was under the contract, and that description should be clear and non-technical in nature, so it can be understood by a layperson who doesn't have any previous experience with the contract. Next slide, please.
Sure, and quickly, Greg, I just want to say we're getting some background noise, so if you are not speaking and are not on mute, if you could just mute your mics, that would be great. And then if you need to talk, you can unmute, but we just want to reduce that background noise. Thank you.
Okay, thanks, Natalie. So the FAR requires 5 main CPAR evaluation factors. They're technical, cost control, schedule, timeliness, management and business relations, small business subcontracting, to the extent that it applies. Not every contract includes small business subcontracting requirements. And then there's a category for other, where the agency can add evaluation factors that are relevant to that specific contract. The agency also has the ability to add sub-factors. So if there are multiple sub-factors that go into the question of cost control or the question of business relations, the agency has the ability to modify the CPAR to account for those different aspects of performance that it wants to evaluate. Next slide, please. So those of you who have dealt with CPARs in the past are familiar with the ratings. there are 5 possible ratings: exceptional, very good, satisfactory, marginal, or unsatisfactory. And anytime you are in a position to, certainly if you're interacting with agency officials about CPARS, or if you are performing on the contract and are privy to your strategy about how to maximize CPARS ratings, or just you are performing functions, oversight functions that relate to how you're going to be evaluated and what your performance is going to be, I really encourage you to familiarize yourself with what each of those ratings means. The FAR has at Part 42 a detailed table that specifies what each of those ratings means in terms of the contractor's performance, and what the agency has to do before giving the contractor each of those ratings, and what the CPAR has to provide. And those are really useful in 2 contexts. One context, of course, is aiming your performance towards getting higher ratings. So having to, understanding that a satisfactory rating is essentially performing the baseline of the work without any major errors or performance issues or problems, but also without ever going above and beyond, or having a major performance win. That's satisfactory. Just doing the work gets you to the middle. You really have to have things that are significant detriments to the government to go lower, or significant benefits to the government to go higher. And in that regard, you can aim your performance to not just do the work, but also find ways to show the government that your performance is providing those benefits. So look at FAR Part 42. There's a table, I think it's table 42-1, that spells all of that out in terms of what each of those ratings means. It's very important to understand what the government has to do to justify those ratings. And that comes in also on the back end of when you want to challenge a rating, verifying that the government has in fact done those things. And so most significantly, if the government is going to give a contractor a marginal or an unsatisfactory rating, it has to do 2 things. The first is it has to cite one or more, and typically 1 is for marginal and more is for unsatisfactory, significant events that the contractor couldn't overcome, performance problems that couldn't be remedied, and how those events impacted the government. So not just that they happened, but also that they negatively impacted the government. And the government has to reference the management tool that notified the contractor of the deficiency. And this is critically important. And I'll talk about it more in connection with a specific case that I worked on. But it's not enough for the government to say the contractor missed these performance requirements. In order to give a marginal or unsatisfactory rating, and keep in mind, those are ratings that can have significant long-term detriments to the contractor's business, the government has to say how it told the contractor that it was failing to perform. What was the mechanism for that notice? It can't be that the contractor first learned of the government's dissatisfaction or of its failure to perform when it got the CPAR. And that's a critically important point. Next slide, please. And along the same lines, in order to justify a very good or exceptional rating, it's not enough to say the contractor did everything that we hope they would do, or we got along with the contractor well. There have to be one or more significant events. Again, one typically for very good, more for exceptional, that in the contractor's performance that gave a benefit to the government, and the government has to explain that. So the result of this system is that giving a satisfactory rating is the path of least resistance for the government. It gives the government more, it involves less work, because in order to justify a satisfactory rating, all the government has to say is that the contractor met the requirements. And the government doesn't have to go to the next step of providing a justification that cites to specific contract events. And something that has been seen as a trend over the last several years is actually that the number of satisfactory ratings is increasing. And while the number of very good or exceptional ratings is decreasing. And it's probably also true that the number of marginal or unsatisfactory ratings are also decreasing, because again, the government is incentivized to give a satisfactory rating. It looks like, Chris, you have a question?
Yes, thank you. I know that on the SAM.gov CPAR website, there are some reporting tools where you can pull various statistics for what the government, the ratings the government has issued sort of globally. I think that's been a while since I looked at it, but that ties into my question is, what is the data that you base that on in terms of, what you just said, the trend for stats is higher and so forth?
A report that I read yesterday when I was preparing for this presentation, which I will follow up on and send to you.
Terrific, thank you.
I'll dig that out and get that over to you.
Okay.
So that's important to keep in mind, again, because it's very easy for the government to give a satisfactory rating, but how can you as a contractor aim your performance to make it easy for the government to justify a very good or exceptional rating? That's a critical part of your CPARS strategy, and we'll talk about that in some more detail when we get to the best practices. And finally, you've all seen this. There's usually the recommendation section where the contracting officer or the official completing the CPAR says, given what I know today, I would or would not recommend this contractor for similar requirements in the future. It's an interesting one, because even in some of the really negative CPARs that I've seen and counseled clients about, you'd actually be surprised. An agency can give a contractor multiple marginal ratings and yet still recommend the contractor for similar requirements in the future. It's something that perhaps the agency doesn't want to go that final step and say that they would not recommend them. But I actually don't think I've ever. It would be pretty rare to see a non-recommendation, and certainly other aspects of a contractor's performance play into it. So sometimes you had a bad year and you get a couple of marginal ratings, but the contracting officer is aware of this contractor's work from other contracts or from previous contract years, and decides that they would continue to work with this contractor even though they had a rough year on this particular contract. Next slide, please. So this is the general outline of the CPARS process. Typically, an agency will first provide a CPAR to the contractor for its review and comments. Contractor has an opportunity to request a meeting regarding the CPAR. That can be done, must be done in writing and within 7 days of receipt. So if a contractor wants to thinks it would be helpful to talk those issues out with the agency, it has that right. But again, that has to be done within 7 days. So you have to watch that timing. And then there's an opportunity for the contractor to submit comments that will be published in CPARS.gov along with the government's evaluation. And contractors typically do that within 14 days. The total deadline on submitting comments is 60 days, but contractors want to, but particularly if contractors are pushing back on a negative evaluation. Looks like, Chris, that you have a question? Chris, did you have a question?
You're muted,
Yeah,
Chris.
sorry, I was on mute. Please finish your thought there. I didn't mean to interrupt you.
Okay, sure. So, but particularly if a contractor is pushing back on a negative evaluation, the contractor wants to have that information included when the CPARS is first made available government-wide. And after 14 days, the CPAR can go into the system such that it's available for past performance evaluations, for other opportunities. And so a contractor typically gets its comments in within those 14 days. So its comments and the government's evaluations can stand side by side, and it can tell its side of the story if there are negative evaluations in the CPAR. In my experience, agencies, particularly if there's a dispute around a CPAR, don't typically publish right after 14 days. Usually there's a bit of a back and forth where the agency will provide the CPAR to the contractor. The contractor will submit comments within 14 days. The agency will then consider those comments, consider whether it wants to change any of its ratings or correct any of the information. If not, there's usually one line that says that the agency has reviewed the contractor's comments and stands by its initial evaluation or something to that effect. And then all of that gets put out in the CPARS system.
Great. So my question is related to that, and it's been my working understanding that when we, enter our responses within the 14 days, ideally, we have to actually finalize our comments, right, and return the control of the CPARS over back to the government in order for any of our comments to even show up next to the government's. Does that make sense?
Yeah, and I think that's right.
That's right. Okay. Because sometimes we have, a pretty elaborate, extended response that we want to enter, and we know we're going to disagree, and we know we can get into the system our general objections, but sometimes we want more time. But as I understand it, unless we actually finish entering all of our responses and finalize our responses, nothing that we've entered will actually show up at day 15. Is that correct?
I think that's right. And you interact with the system. So in practice, you may have a better sense of this than I do. It's my understanding that you can continue to comment up to 60 days. After 60 days, you're locked out of the evaluation. But up to 60 days, you can continue to comment. It's just that it will be published without those initial comments after 14 days, or it can be.
Okay. Thank you.
Okay. Okay. Next slide, please. Okay, so we're going to talk about CPARS and how they are used in some different contexts. One context is bid protests. The most important thing I can say about CPARS and bid protests is that you, as in nearly all cases, will not have the opportunity to challenge the substance of a CPAR in a bid protest. So if you are not awarded a contract and you protest, and when your attorneys are reviewing the agency report, they see that you didn't get the contract because of this wildly unfair CPAR that's on your record. Pointing that out in the bid protest context will get you nowhere. It is too late at that point, unless there's some real strong allegation of bad faith. The GAO has said that they won't even consider those arguments. And so, again, the time for challenging the CPAR, as we'll talk about in the next section, is when you receive it, not later on if it comes back to haunt you. Otherwise, CPARs come up in bid protests the same way as any other past performance information. Again, this is information that's available to government evaluators. They're free to use it. It's at their fingertips. And so sometimes protesters will say you gave too much weight to this CPARS and you dinged us on it. Sometimes they'll say you should have given more weight to this negative CPAR that the awardee received. And so those are the types of arguments that will come up just like any other kind of a past performance record in a bid protest. Next slide, please. So then the question becomes, what can you do if you get an unfair CPAR? If you have a CPAR that you think is inaccurate, that is based on incorrect information, a CPAR that is just based on potentially a bad relationship with the agency and you're being punished by them. How can you dispute that given the extensive potential negative impacts that having bad CPAR ratings in your record can cause? And the answer is, this of course assumes that you've gone ahead, although you don't have to, but typically you'll first try to convince the agency that their CPAR ratings were wrong. So you might ask for a meeting to explain your position. If that doesn't work, you'll go ahead and submit those comments, usually within 14 days. So at least the record will reflect your side of the story. And in some cases, those comments, you can point out errors in the agency's factual statements that will cause them to make corrections. But if that doesn't work either and the agency is sticking to its evaluation, what can you do? Well, there's a disputes process for that, and it's the same disputes process really that you have with respect to any contract. It's under a law called the Contract Disputes Act, and the Contract Disputes Act allows the contractor to sue the government through an administrative process in order to obtain relief on a contract. And usually, that's the contractor suing for more money, right? You made a request for an equitable adjustment on a contract, it was denied, so you engage the disputes process and try to push the government to pay you the money. Sometimes before going to that formal step, you'll see a contractor that might put in a letter or request for reconsideration or something to that effect, but that's not required. What is required if you want to go to the formal process is to submit a claim. And a claim, for those who are familiar, under the Contract Disputes Act, has a formal meaning. It is a written document submitted to the contracting officer that asserts that the government should take some action. Usually it's pay the contractor money, but in this case it would be to revise or withdraw certain CPAR ratings, and then request a final decision from the contracting officer. And that final decision, which must be in writing, if it goes against the contractor, then triggers the contractor's right to take an appeal. And there are two different forms for an appeal. Under the Contract Disputes Act, you can either go to the Court of Federal Claims or you can go to the Board of Contract Appeals. There are two of them. One is the Armed Services Board for DoD and NASA contracts, and then the other is the Civilian Board for all the other agencies. And those, there are a certain number of CPAR cases that are litigated every year, and those cases, the Court of Federal Claims or the Board of Contract Appeals typically can't order the agency to change the CPAR ratings, but can tell the agency, listen, this rating is wrong. It should be withdrawn and redone. Next slide, please. The standard for when the court or a Board of Contract Appeals is reviewing a CPAR is whether it was fair and reasonable. And so that's an important standard to keep in mind if you do get to this point, because it's not very deferential. It's not whether the agency had a reasonable basis. It's whether, excuse me, fair, I should say fair and accurate, not fair and reasonable, fair and accurate. So it's not whether the agency had a reasonable basis or could have reasonably found those ratings, but whether in fact the CPAR was fair to the contractor, whether the factual information in the evaluation is accurate. A couple cases I've cited here, one of them, Kelowna's Shipyard, the contractor challenged the CPAR, but didn't get very far because the contractor didn't have evidence, didn't have objective evidence that it pointed to show that the agency's evaluation was unfair or inaccurate. And so it's important to remember that the more objective evidence, the more fact-based arguments that you can make when challenging a CPAR, the better off you'll be. The more subjective the argument, the more it relates to an agency's discretion, the harder it is to prove. I think we have a question.
Yeah, hi, this is Jim Laurie. If you would you choose, in your experience, to go to either Court of Federal Claims or ASPCA with a claim? In other words, you know, if you're going to get a DOJ attorney, are they more likely to be better to work with than the agency counsel, especially if you have a bad relationship with them already?
Yeah, I love that question. There are a lot of strategic factors that go into that. I tell you one thing that has led me to advise to go to the court, to go to the Board of Contract Appeals on these over the Court of Federal Claims is that Court of Federal Claims docket is public. And so if you go to the Court of Federal Claims, there will be a public document noting that you had a marginal or unsatisfactory CPAR rating that your competitors can see. And then turn around and use against you in a bid protest. And at the ASPCA, you don't have anything that's public until there's a final decision, in which case, you know, you're likely 2 years down the road, and it's not as easy to find. So that's one major factor. The other factors you mentioned, certainly, you know, sometimes the DOJ lawyers are of higher quality, so they're harder to litigate against, but might be more objective than the agency counsel may be. So all of those are good factors, but I typically recommend the Board of Contract Appeals just for the reason I just stated. Great question, though. I mean, I let's talk offline. I could talk about that one all day.
Thanks.
I think we have another question from Chris.
Yeah, me again. The last bullet here on your slide is really interesting and a relief to see that. Which case did that conclusion arise from? The process violations.
So thank you for raising that. I'm conscious of the time here. I'm going to try to get through this as quickly as I can because I do want to get to best practices. But that in part arises from a case that I litigated at the ASPCA most of last year for a defense aviation services provider that had some marginal CPAR ratings that it strongly disagreed with. And the contract included some objective performance metrics that the contractor had not met. And so the agency on that basis gave a couple marginal CPAR ratings, the contractor felt very strongly that its failure to meet those requirements was due to really unforeseen and unforeseeable circumstances that were beyond its fault or control. And so the agency was really unfair. The agency was the Air Force. The Air Force was really unfair in assigning those ratings. It was going to be probably a tough case because, again, the question of whether something was beyond the contractor's control is not really objective. That's a subjective piece. But what really worked to our benefit was the requirement for marginal ratings, as I cited before, that the agency cite to the tool that was used to notify the contractor of the deficiency. The Air Force in this case had never notified my client that it was below the required performance thresholds. There was some question of whether my client could have figured it out on its own and made those calculations, but ultimately we argued, I think, persuasively that it would not have been able to, and certainly the agency could not show that it had informed the client of those alleged deficiencies. And so ultimately, we didn't end up getting a decision on that case. Shortly before it was set to go to a hearing, the Air Force withdrew the CPAR and took corrective action. Yeah. And so, that I think had it not been for, well, I know because I saw just from discovery, they recognized that the failure to notify the contractor of the deficiency prior to giving the marginal rating was problematic for their case. Yeah. So again, subjective is always going to be tough. If you can point to objective errors, right? We actually did meet that deadline. We actually did exceed that performance, or at least meet that performance threshold. That's where you're going to have success. Or process errors.
Yeah, great. Yeah, I think we've had process issues with the Air Force before too, in fact, and they withdrew the rating in our case too. But it sounds like James and I could pick your brain about some really nitty-gritty things here at some other point. So carry on, please, to your
reach out. Glad to do that anytime. Let's talk about the best practices. Next slide, please. Some of these I think are intuitive, but want to make sure that we talk through them. Certainly communicate with your customer, identify, address problems early, make sure that you understand what your customer's pain points are. Sometimes people are afraid to ask, just like everyone is in their everyday life. You don't want to ask, are you satisfied, because it's an awkward question and you're afraid of the answer. But the more information you can get, the better you can aim your performance to getting higher ratings. Learn from the customer. What does exceptional performance mean for that customer, right? If satisfactory is simply meeting the contract's requirements, what do we have to do to get to an exceptional CPAR rating? I've never heard of a contractor being dinged for asking that question. And I think it's a really good dialogue to have. Really understand the performance metrics of the contract. If there are service level agreements, performance thresholds, certainly delivery or completion dates. All of those are the factual, objective data points that feed into a CPAR rating and are really critical. And then track and gather that objective information. Have a CPAR folder. Have a CPAR strategy. How are we going to get to an exceptional performance rating? And let's have all the information showing our exceptional performance and keep it in a contract folder that's available whenever we have the opportunity to tell the customer about all the great things that we're doing. I think we have a question.
Yeah, I have a question on the when you talk to the customer and you talk about what does exceptional performance look like, sometimes we get the feedback that I don't give exceptionals. And do you have any suggestions or best practices on responding when they say that?
Yeah, I mean that's not really. I think that's probably more of a customer relations issue that is just trying to say are there additional things we can do, or can we go above and beyond? You may not have given exceptionals before, but we're going to be the first time. Those kinds of things might help. Some agencies or subgroups within agencies, some contracting offices are just hard graders, and that's a fact of life on this, unfortunately. So no, I don't have any magic answers for that, except continue the dialogue and try to get them to a better answer under any way you can.
And I think when they're hard graders, it's important to really understand the evaluation criteria. And when you interact with them, take every opportunity to reinforce the criteria or the examples you have or performed that show you performed in an exceeding manner.
Yeah, absolutely. That's a great point, right? Especially if it's subjective. So the threshold is 15%, and we've consistently been at 25%. That to us is exceptional. The more you can do that through objective performance metrics, the harder it is for them to say we don't believe in exceptional. Next slide, please. Finally, take opportunities when you're submitting status reports, performance reports, when you're meeting with the customer. Anytime you have opportunities, take the opportunity. Don't be shy. Highlight your successes. Don't assume that the customer is focused on those issues. They're focused on the problems or the major issues that they have to get through that day. They're focused on their pain points. They may be taking your successes for granted. So make sure that you're highlighting those in the most sticky way possible, so they walk away and remember that when it comes time to draft your CPAR. Make sure in the CPAR that the description of the contract work is complete and accurate. Again, that CPAR is also being used for evaluation purposes, and one of the evaluation points will be whether that work was similar to the work that you're now proposing to perform. And so the better description in the CPAR, the better chance of finding that work to be similar, or at least getting a full understanding of the evaluators on the new opportunity of what the old work was. So if you find a CPAR description that's too general or doesn't fully capture your performance, you should try to correct that and make sure that it does. Don't just focus on the evaluations. This is probably intuitive, but make sure your comments are detailed and specific and not just general. You want to point to specific events, specific performance metrics, and not just say that you disagree or the ratings were unfair. And use the comments when you submit comments to remind the customer about successes. Oftentimes the need to write comments is particularly acute when you get a negative rating. But if you get a satisfactory rating and you really think you were exceptional or very good, write a comment there too and say we consistently exceeded the performance thresholds. We overcame this major issue on the program that you were facing, etc. And finally, I get oftentimes when a client runs draft CPAR comments by me, they feel a lot like venting. They look like there's argument, and the agency was all wrong. They're unfair. They're mad at us because we submitted an REA that they didn't want us to submit. Whatever else it is, they like the last contractor better and they're punishing us. Try to resist that to the extent possible. You want to be persuasive. If there really is something compelling that you want to include, that you want to stand side by side when somebody looks at the CPAR, then you can include it. But the more you can do to persuade as opposed to just arguing with the rating, the better off you'll be. I think that's the last slide. I think the next one is questions. So I'm happy to stay on for a few minutes. I know we're at the end of our time, but if people have more time, happy to answer any other questions or engage in any discussion that would be useful.
Greg, this is Craig Duncan. I had a question that I put into the comment side. Can you see that?
I see there's a chat.
I'll just read it to you. Can you provide kind of rules of engagement or a brief primer relative to our ECC being able to submit formally or informally a self-evaluation in advance of the government doing it? We definitely do it, but wanted to find out your thoughts on best processes for that.
Yeah, I think that is something that some clients do, and I think if you have a receptive agency audience, that can certainly be helpful. One best practice there, well, a couple best practices. Certainly, I think that's something that for as far as rules of engagement, you should probably let the customer know that it's coming. You don't want to just hit the customer with that cold. We like to, we know your CPAR process is about to kick off. We'd like to submit some of our self-evaluation and some thoughts for that. We'll submit that in writing. Who should be the distribution for that? Obviously, the contracting officer is the key recipient. And as far as best practices go, I think aligning your self-evaluation to the CPAR is certainly one of them. Right? You want to make the rule of the road with government procurement is always make the agency official's job as easy as possible. And so if you have the opportunity and you could give them direct information that that they can then take and use to inform what they have to do on your CPAR, then that makes it very easy for them. And so putting your categories into the same categories that they're going to be evaluating, that I think that's something that's helpful. And then again, really citing more so as much as possible to objective things, meeting deadlines, exceeding performance metrics, positive interactions, problem solving, anything that is specific and objective is more likely to be used by the government rather than your